Good afternoon. My name is Mark Chenoweth. I'm General Counsel of Washington Legal Foundation. WLF is celebrating our 40th anniversary of keeping free enterprise free, which we pursue through a unique combination of litigation, publishing, and public communications like today's media briefing. Thank you to those of you joining us in person and also live online. WLF has published a number of articles and blog posts criticizing different aspects of the Consumer Financial Protection Bureau and its overreaching regulatory activities. But the single biggest effort that WLF has undertaken in this area is representing our client, Chance Gordon, in his cert petition to the United States Supreme Court, seeking to have a flawed judgment against him reversed. Because the Supreme Court will soon be making its decision on whether or not to hear the Gordon v. CFPB case, we are conducting today's briefing to underscore just how important we believe this case to be. With me here to discuss the case are two of my WLF colleagues who have been instrumental in preparing WLF's briefs for Mr. Gordon. First, we will hear from Richard Samp, WLF's Chief Counsel, who will address why the court should grant cert in this case, including the ratification problem that we think is inherent in this case. Then we will hear from Cory Andrews, WLF's Senior Litigation Counsel, who will discuss the Article 3 standing problems that we believe CFPB faces in this case. Finally, we are privileged to be joined today by Gregory Garre, who authored the National Chamber Litigation Center's amicus brief in this case, supporting Mr. Gordon's cert petition. Greg is a partner at Latham & Watkins and the global chair of Latham's prestigious Supreme Court and appellate practice. He served as the 44th Solicitor General of the United States from 2008 to 2009. He is the only person to have served as Assistant to the Solicitor General, Principal Deputy Solicitor General, and Solicitor General. So he brings a wealth of experience to today's discussion. He will back cleanup and touch on the U.S. Chamber of Commerce's arguments in its amicus brief, as well as offer some additional insights from his perspective as a former 10th Justice of the U.S. Supreme Court. After the speakers' presentations, we will take questions. For those of you online who may have questions, you can use the Q&A sidebar function in your live streaming viewer. If you have the viewer maximized and you want to ask a question, you'll have to minimize back down to access the sidebar. The questions are conveyed directly to us and not seen by other viewers. Also, if you're interested in seeing WLF's briefs or the press releases that we have issued in this case, please visit our website at www.wlf.org. At the top of the homepage of the website, you'll find a link to the WLF Gordon case page. If you click on that link, you will be taken to all the materials that we have issued in connection with this case. Before turning over the podium to Rich, let me provide just a little bit of brief background about this case. This case began when Richard Cordray was recess appointed as Director of the Consumer Financial Protection Bureau on January 4th of 2012, a day on which the Supreme Court subsequently found that the U.S. Senate was not in recess. Although Mr. Cordray was later properly appointed and confirmed to his post in July of 2013, the CFPB operated under his constitutionally defective recess appointment for 18 months. This case asks whether or not there will be any consequences for that defective appointment. During the time when Cordray was serving unconstitutionally, the CFPB brought an enforcement action against WLF's client, Chance Gordon. It obtained summary judgment against him in U.S. District Court in June of 2013. Mr. Cordray was confirmed the following month, and in August of 2013, he published a 4-sentence statement in the Federal Register purporting to ratify all of the actions that he took when he was serving in that defective capacity. It's now up to the Supreme Court to decide whether or not to accept the Ninth Circuit's 2-to-1 decision that this blanket ratification suffices, or whether there should be more consequence for an unconstitutional appointment. Rich, you can take it from there.
Thank you very much, Mark. I think it's interesting that in this particular case, CFPB has continued to assert the propriety of everything it did until it was forced to back down. So that in the district court, CFPB insisted that Mr. Cordray had been properly appointed on a recess appointment, and it was only after the case got out of the district court that finally the U.S. Supreme Court in the following year issued a decision that said that in fact on January 4th the Senate was not in recess, therefore Mr. Cordray's appointment was not proper. And it was only at that point, for the first time, that the CFPB started to say, well, okay, maybe we had no authority to file this lawsuit and to prosecute it and to get a judgment, but nonetheless, there was a four-sentence ratification notice that was published in the Federal Register after the district court proceedings had been completed, and that was good enough to ratify everything that had gone on. Well, if that sort of ratification is sufficient to overcome deficiencies in recess appointments, then really there is nothing left to the recess appointment clause, and that's the basic gist of our cert petition that we have pending in the Supreme Court, that the Article 2 of the Constitution imposes very strict limits on when people can be named officers of the United States authorized to act on behalf of the United States. And if it doesn't mean anything when these provisions are violated, that a magic wand can be, after the fact, waived, then there really is nothing left to these limitations. One of the things that I think will particularly interest the court in this issue is that really ratification is a new concept being pushed by the federal government in this case. In fact, never in the Supreme Court's history has it ever upheld ratification of by the executive branch of a previously invalid action. The only time that the issue ever came to the Supreme Court's attention was back in the 1990s, a case called Federal Election Commission versus NRA Political Victory Fund, in which there was an effort by the Solicitor General to retroactively ratify a prior invalid action, and the Supreme Court said, no, it's not proper in this case. In fact, the facts of that case and what the court said there apply directly here and would prohibit a ratification. But I think more importantly, from our perspective, the Supreme Court has never upheld ratification at all, and the FEC versus NRA case is the only one that's ever come before it. So we're hoping that this will be of significant interest to the court to decide an issue of, it's an important issue of federal constitutional law that's really never been decided by the court. Now, the CFPB cites a couple of older Supreme Court cases that they say supported on ratification, but those decisions have nothing to do with this case. They all involve cases where the Congress stepped in and said, well, you know, at one point in the past, the executive branch didn't have the authority to take certain action, and we're going to retroactively ratify that decision by passing a new law. Well, new law was passed here. And in fact, Congress on several occasions has made it clear that it does not like ratification by the executive branch. It passed a law back in the mid-1990s called the Federal Vacancy Reform Act, which said, okay, we're going to allow, in very limited circumstances, vacancies to be filled temporarily by career employees until a new person can be named by the president to fill that vacancy. But unless you comply with the provisions of this Vacancy Act, we hereby prohibit any sort of ratification. So you have a situation where Congress has said we don't like ratification. We also have a situation here when the CFPB was created by a law called the CFPA back in 2010. When they passed the law, they very explicitly said, we do not want any enforcement actions brought by the CFPB until there has been a director who has been confirmed by the United States Senate, because the CFPB was a somewhat controversial agency when it was being proposed by the Obama administration, and that was the compromise that Congress came up with. Nonetheless, there clearly was not a confirmed director at the time that they brought this enforcement action. So you have a situation here where the executive branch is not only trying to retroactively ratify action to the detriment of our client, but it's also trying to do so against the will of Congress. And we think that that is a particularly appropriate circumstance in which the court ought to step in. With that, I'll turn it over to Cory to talk about some of the jurisdictional issues.
Thank you, Rich, and thanks everybody for tuning in and coming today. One of the other aspects about this particular suit that is troubling is the government's insistence that, for some reason, Article 3 standing is not really implicated in this case. So the government takes a position that Cordray's recess appointments clause defect was so egregious that it needed to be ratified. And yet, for some reason, that defect is of no effect to the principal activity of the CFPB in this case, which was the enforcement action in federal court. So this isn't a case like some others which are equally important, where an agency is being challenged for its authority to enact regulations or even to conduct sort of internal proceedings. This is a case where an agency went into the federal courts and used the federal courts to ultimately deprive a person of several $1 million in assets. Whatever else ratification may do, we would submit that ratification surely cannot ratify a federal court adjudication. And there's certainly no case like that that the government cited. Instead, the government says it's the executive branch that has standing in any particular case, not any particular individual. The problem is there's no one in the case who had executive branch authority. So we know that the executive branch didn't bring this suit. Richard Cordray, for example, who authorized the suit, the government concedes was improperly appointed, and so no Article 2 authority had been vested in him. And because the CFPB was a brand new agency, the way the statutory scheme is put together, as Rich described, actually no one could bring an enforcement action until you had a properly confirmed director of the CFPB. So the Supreme Court has been clear, and most first-year law students know, that Article 3 standing is irreducible. It's a bedrock requirement to come into federal court, and it must exist not only at the time suit is filed, but through all proceedings of the case, at every stage of litigation. And so Article 3 standing is historically satisfied in one of two ways. Number one, the executive branch and its duly appointed officers of the United States have relaxed standing because they have Article 2 authority to enforce the law. They're able to enforce the sort of general public grievance that the laws are being broken. But as cases like Lujan and now Spokio make clear, private citizens don't enjoy that authority. They have a much higher hurdle. They have to satisfy an injury in fact requirement. They have to show that injury is both concrete and particularized. They have to show that that injury is traceable to the defendant and that it can be redressed by a favorable court decision. Now, the government doesn't even attempt to satisfy that or claim that it needs to, but obviously we know the reason why it couldn't. And as Rich also mentioned, it's not just the Constitution that makes clear that CFPB lacks standing in this case, but the statute that Congress enacted expressly precluded these kinds of suits. And so this, we think, is a unique case in that it raises very important separation of powers concerns. The whole basis for standing under Article 3 is to police the separation of powers of the three branches of government. And this is a case in which you have not just the Article 3 interest of the courts or the Article 2 interest of the executive branch, but the Article 1 interest of Congress, all converging into one moment in federal district court. And we think because of that, this case presents some very unique issues for the court to decide.
So I'm going to pick up on where Cory left off. We filed a brief on behalf of the U.S. Chamber of Commerce in this case, and we focused on the standing issue, which also was the basis for the dissent in the Ninth Circuit by Judge Ikuda. And the Ninth Circuit, in its dissent, made clear that CFPB lacks standing in this case. And we focused on the standing issue, which also was the basis for the dissent in the Ninth Circuit by Judge Ikuda. And the Ninth Circuit, in its dissent, made clear that CFPB lacks standing in this case. And we focused on the standing issue, which also was the basis for the dissent in the Ninth Circuit by Judge Ikuda. And I think, generally thinking about this case compared to other cases involving the CFPB, there's a case pending before the D.C. Circuit right now, the PHH case, which deals with questions about the structural constitutionality of this agency, and in particular, whether or not the Constitution at least required that the director of the CFPB could be removed for any reason by the president, as opposed to for cause. That case concerning the structure of the CFPB is really quite different than this case, which is really about the way that the agency exercised power in its early years when it had no confirmed head. And just, sort of reiterating the basic standing problem. Under Article 3, the Supreme Court has made clear time and again litigants have to have a direct stake in the outcome of a case. And usually that's no issue for the government at all because its stake in the outcome of enforcement proceedings that the government brings is tied to the executive's duty to take care that the laws be faithfully executed under Article 3. But here the problem for the CFPB is it had no Article 2 authority to act, the argument goes. And this is the way that the dissent put it below. Who was exercising the executive power of the United States needed to bring the civil enforcement action, not Richard Cordray. He was not properly appointed by the president and so was not an officer of the United States at the time the action was filed. And not the CFPB. Without an officer of the United States, it was a mere congressional creation that could not exercise executive power. In fact, no one had the executive power necessary to prosecute the civil enforcement action in the district court. And so instead of having an executive agency authorized to assert the executive authority under Article 3 of the Constitution, what you had was an executive entity essentially bringing what, if a private litigant brought it, would be known as a generalized grievance or generalized effort to claim that someone hasn't obeyed the law. And that, the Supreme Court has said time and again, in the private party context, is not something that gives rise to Article 3 standing. And so then the question is, why does it matter here? Well, first of all, the Supreme Court has emphasized time and again, particularly under the Roberts Court, that principles of standing really go to the fundamental role of the judiciary in our constitutional system and are part of the structural safeguards to protect liberty. And then if you think about it in more practical terms, Attorney General Robert Jackson, of course, went on to serve in the Supreme Court in the 1940s and 50s. When he was Attorney General, he warned of what he called the immense power that the government has to, quote, strike its citizens, not merely with individual strength, but with all the force of the government itself, giving the prosecutor more control over life, liberty, and reputation than any other person in America. But then he wrote of the structural safeguards that we have in place for the prosecutors, and he emphasized that one of the ways to ensure that this power is not abused is to vest it only in officers of the United States who have, quote, won the expression of confidence in their character by both the legislative and executive branches of government. But here we had that lacking, at least during the time period issue when these prosecutorial actions, enforcement actions were brought. Mr. Cordray had lacked the legislative approval for his actions. And that seems particularly relevant here, given that one of the criticisms that was made of Mr. Cordray during this period before he was confirmed was concerns about how he would exercise the broad new authority of this new executive agency. So a couple other points before I sit down on the government's response and then also more generally the likelihood of certiorari. The government response was filed by the new administration. The administration had sought several extensions of time to file a response to this petition, and as we know, has been evaluating its positions with respect to the CFPB, and in fact, in the PHH case in the D.C. Circuit, it actually changed its position from the litigating position of the Obama administration to say that the act, to agree with the plaintiffs there, that the act was unconstitutional, at least in part. Here, however, after taking that extra time, the government came in what I think can only be regarded as a full-throated, wholehearted defense of the government's position in the prior administration, arguing on both as to ratification and Article 3 standing that the decision below was correct and did not warrant review by the Supreme Court. I think it's fair to say that with respect to Article 3 at least, the government's main effort is to try to deflect attention from that. They don't really have an answer as to why Mr. Corduroy lacked Article 2 authority to prosecute on behalf of the executive branch. They simply point to the fact that the enforcement action was brought by an executive agency. But of course, that agency, it's undisputed in this case, lacked a duly appointed head during the time that the enforcement action was brought. In terms of the likelihood of cert, having filed a brief supporting certiorari, we of course are hopeful that the Supreme Court will see fit to grant review in this case. I think this case is probably as good of a barometer as any as to whether and how the court has changed now that it is back to 9 justices. We had this period where the court had 8 justices, and I think there was a general consensus that the court seemed to be scaling back a little bit, treading very carefully and staying away from areas that might have been viewed as more controversial. And so now it has 9 justices, and I think this case gets into areas that are going to be a little bit more higher profile because of the nature of the agency here. But I think that it'll be very interesting to see whether or not the court grants certiorari here, which may be as good of a sign as any that the court really is back to work with a full complement of justices. One other interesting thing about this case is, at least in terms of standing, one of the decisions going the other way on standing comes from the 10th Circuit, which of course is the circuit from which Justice Gorsuch came. Justice Gorsuch was not on the panel, but one suspects he might have a particular interest in the views of his former colleagues on that question. And the dissent in this case is very forceful, written by Judge Ikuda on the 9th Circuit, is a well-respected judge. And I think that that's something, too, that the justices will pay particular attention to in deciding whether or not to grant certiorari in this case. They no doubt are aware of the PHH case in the D.C. Circuit and may have some indication that there may be something coming its way in the not-too-distant future. But this case really concerns the exercise of authority by the CFPB in a different way that's manifested in the D.C. Circuit case. So I think it's likely that the court will view the issues here as quite distinct than those pending before the D.C. Circuit. Thank you.
Thanks, Greg. If there are any questions in the audience, just raise your hand and let me know. The first question that we have, Rich, is for you. As you indicated in your talk, there has been ratification in the past by Congress of executive branch action. Why is ratification of Mr. Corddry's action by the executive branch itself any different? Why is that a problem?
Ratification by Congress really goes to the question of Congress's ability to retroactively change the law. And it is pretty well accepted now, for example, that Congress has the right to change the law by imposing taxes retroactively. And so to say that Congress can ratify past action, many of these past cases were tax cases. So it really is just another way of saying it's okay for Congress to pass retroactive laws. I think more fundamentally, when you have the executive branch trying to uphold what it previously didn't have the power to do, you have the serious problem of Congress the executive branch trying to get around Article 2 limitations. Those same issues don't really arise when Congress says, we think we are going to ratify what went on before, because after all, the appointments clause is put there to make sure that Congress can check the executive branch, and if Congress doesn't want to apply that check, there's perhaps less reason for the courts to be concerned.
Cory, the next question is for you, and I think Greg got into this a little bit, but love to hear your answer as well. Why does it matter if the court overlooks standing in this case?
Yeah, well, for one thing, it kind of makes a mockery of all the Supreme Court's centuries-old standing jurisprudence, right? I mean, this is one of the one of the troubling things about this particular case was it's such a sui generis situation that we couldn't find a circuit split because no case had ever held that before this one, that someone purporting to represent the government who was unauthorized to represent the government somehow had standing to enforce federal law. That case just doesn't exist. Now, the Supreme Court did decide a case named Providence Journal, which involved a special counsel. I noticed that special counsels are in vogue again today. But that particular special counsel did something that only the Solicitor General is authorized to do, and he sought cert with the Supreme Court, and he did so without the authorization of the Attorney General or the Solicitor General. And the court specifically said, lacking any authorization to act on behalf of the United States, we are without jurisdiction. And we think that case is the same thing as our case. Cordray and CFPB lacked any authorization to represent the United States, and the district court was without jurisdiction.
Greg, you mentioned that Judge Akuta's dissent in the Ninth Circuit was focused on the standing question. Do you think that if the Supreme Court were to grant a cert in only one of the two questions, do you think it would be more likely to grant on the ratification where there's more of a circuit split, or on the standing question, or do you think this is a situation where it's going to be both or none?
No, I think it's quite possible that the court could grant on one question and not the other. I mean, obviously they're related in that they both concern the propriety of this enforcement action, but they're quite different in that the standing question might be viewed as, a little bit more narrow in terms of the impact as it plays out with respect to pending cases where the issue can still be raised. Standing is also something that the court may feel a particular obligation to take an interest in. It's an issue that the Roberts Court has focused on generally. It's a structural constitutional protection that obviously uniquely implicates the courts. And so I think it's one that the court may be particularly concerned about in terms of the consequences of this ruling.
Rich, a second question for you. When the court in Noel Canning issued its decision that the Senate was not in recess on January 4th of 2012, that, of course, that case, NLRB v. Noel Canning, directly implicated, I believe, 3 appointees to the NLRB, the National Labor Relations Board, in addition to implicating indirectly Mr. Cordray, who was appointed on that same day. We know from the way that the NLRB has handled its business subsequent to that it went back and it did not issue a 4-sentence perfunctory blanket ratification the way that Mr. Cordray did in the Federal Register. Rather, it went back and looked at each decision, and at least with some degree, I won't speculate as to how much, but with some degree of thoroughness, went back and looked at those decisions again with a properly constituted board. If the Supreme Court were to deny cert in this case, do you think that the executive branch in the future would be likely to follow what the NLRB did and go back and carefully look at each of its prior decisions, or would it take the CFPB shortcut that Mr. Cordray took and just issue a blanket ratification of the kind that we saw here?
Well, it would certainly be strongly tempted to take the second route. If you can get away with a shortcut, you can expect most government employees would do that. In fact, there is a serious circuit split on this very issue. I mentioned that the U.S. Supreme Court has never upheld executive ratification, but several circuits have, but they've done so under distinctly different standards. The Ninth Circuit, in this case, said that a blanket ratification like this is totally proper. Other courts of appeals have said we are only going to uphold ratifications by new executive branch officials who have been properly appointed if they give a serious consideration to the previous decision, and that a blanket ratification of this sort will not do. So that even if cert is denied in this case, there will still be authority to say that what CFPB did here was wrong, and I am hopeful, therefore, that federal administrators would not go along with what the Ninth Circuit said. But you're absolutely right that if cert is denied, the temptation to do so will be that much stronger.
Greg, the next question is for you. What was the rationale for the government filing against CFPB in PHH, but in favor of it in the Gordon case?
Well, I think this gets back to the point that there are very different issues involved in both cases. PHH involved in the issue before the en banc D.C. Circuit involved a question about the statutory structure of the agency and whether it simply amalgamated too much executive power in an agency that the president could remove its head for any reason, given that there was a single head. And the issue here is quite different. It's a standing issue, and we suspect that the government, the new administration, took a careful look at it. It did ask for, I think, 3 separate extensions of time to file its brief in this case. But again, I mean, the opposition brief that it filed, I think looks pretty much like what one might suspect an opposition brief filed by the Obama administration would have looked like. It's a very, wholehearted defense of the ruling below. And so in that respect, I don't think that they've shied away from supporting the CFP's position in this case.
Are there any other questions from, there is one on its way, hold on. How many other enforcement actions were impacted by Cordray's ratification? Would they have an action if the court reverses? Rich, do you have a thought on that?
My understanding is that this is the only action that would be affected. First of all, I believe that in the year 2012, there were 8 enforcement actions that were filed in that calendar year by CFPB, and only one defendant, Mr. Gordon, chose to fight those charges, so that the other cases were all settled, so they aren't going to be affected. There may have been a couple of cases in 2013 that were challenged before the confirmation of Mr. Cordray took place in July of 2013. However, I believe that the only defendant who raised the issue from the get-go of the invalidity of the Cordray appointment was our client, Mr. Gordon, so that really, if you don't raise the issue in the district court, I think it's generally assumed that you have waived it. So frankly, on this particular issue, the only person affected is Mr. Gordon. However, there are many cases in recent years where federal agencies have tried to ratify previously invalid actions. So this issue is going to arise in the future. That's why I'm very hopeful that the court will decide to address it now. And one brief point that I forgot to mention.
Yeah, I was just going to ask for final thoughts, so go ahead and
okay.
I'll come back to you.
I was just going to say that it may already say this on our website, but the Supreme Court is going to be conferencing this case this coming Thursday, and the next day on which it will be issuing orders is a week from tomorrow, Tuesday, the day after Memorial Day. So we may hear an answer as soon as then. Actually, we probably would prefer that they decide to hold off for a week or two, because then that would increase the chances that review would eventually be granted.
Cory, final thought?
Sure. This case is really, at the end of the day, is about the separation of powers. That's, we believe, the reason that the court should intervene, grant review, and reverse the Ninth Circuit. If you take the government's argument at its face, it renders both Article 2's Appointments Clause and Article 3's Standing Requirement a nullity. And even if somehow the Article 2 defect could be overcome, we take the position that that doesn't save the Article 3 defect in and of itself. For example, the government in this case is purporting to ratify something. What is it purporting to ratify? Well, the overwhelming majority of the harm that was done to Mr. Cordray was a result of a federal court enforcement action. We have no way of knowing, for example, how the district judge would have ruled if the government had conceded in its summary judgment papers that it lacked authority to bring this action because its director was invalidly appointed, for example. That, it seems to me, is a very important question. It's not just a mere formalism. It's a substantive question that goes to the very heart of a sort of guarantee of liberty, which the structural protections of the Constitution are there to preserve. And that would be my parting thought.
Yeah, I think I would say that in some ways the best thing that the government has going for itself in this case is this case does present, somewhat novel issues that don't seem to have risen before in our history. And at the same time, though, that novelty itself may cause some justices to have particular concerns about, some of the problems that we've talked about today, and they may see fit to grant review, notwithstanding the existence of the sort of entrenched circuit conflict that the justices typically look for, because of concerns that this is an agency has gone too far. We need to lay down a marker that this is not an appropriate exercise of federal power under our separation of powers.
And let me just add a concluding thought as well, and that's that if ratification can occur quickly and effortlessly, then the incentives change. A future president could simply recess appoint his chosen or her chosen nominee when the Senate is not in recess, let that person get to work on the president's agenda right away, as Cordray did, and dispense with Congress's advice and consent role for the time being. Then at a later point in time, perhaps with a friendlier Senate, perhaps with a different nominee even, although that wasn't the case here, the president could get someone confirmed who could then issue a cursory Cordray-style ratification, suddenly making all of the invalid actions legitimate. And even a valid recess appointment only lasts until the end of the next Congress under the Constitution. But theoretically, this kind of a hide and seek strategy could be used for an even longer stretch of time. So I think that to the question that Rich was answering about whether there are other enforcement proceedings pending or not, I don't think that's really the significance that this case has. I think it's that playing hide and seek with a constitutional provision like the recess appointments clause risks dangerous consequences. And whether the court opts to closely examine Gordon v. CFPB will have significant ramifications for all federal agencies, those whom they regulate, and the survival of the Constitution's constraint on the executive appointment power. In short, the Supreme Court's answer to what counts as valid ratification in the context of a faulty recess appointment will matter a lot for the future of limited government. Thank you, everyone, for joining us today. We appreciate your tuning in to the immediate briefing and hope that you will stay tuned to find out whether or not the Supreme Court grants a cert in Gordon v. Consumer Financial Protection Bureau. Thank you very much.